every Tuesday from 5 p.m. Central Time from Reddy Neumann PC. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Today we want to talk about H-1Bs and entrepreneurship. What are the circumstances when an H-1B beneficiary can own part of the company? Can that company be the one sponsoring them? And there is a proposed regulation that is going to modify that, so we'll talk about that as well and when that might come into play. And a common question that we get is, what happens if I get a promotion while I'm in the middle of the PERM process or before my I-140 gets approved? Can I take the promotion? Should I take the promotion? Is it going to make me have to do things over again? And then right now we're getting a lot of questions about people who are wanting to change status from H-1B to H-4, but also apply for an H-4 EAD because they're eligible for it. How do you make sure that the H-4 and the H-4 EAD get approved at the same time so that the person can transition seamlessly from the old status to the new without any kind of gap in employment authorization? And lastly, we wanted to do a little refresher on the Child Status Protection Act. If you have children that were not born in the U.S. And you're from a backlogged country, how to know whether their age is locked. What exactly does that mean? How do you know if the Child Status Protection Act can actually help your case?
First thing, Emily, that there's been a change in the regulations, at least proposed change in the regulations with regards to the H-1Bs owning the company, working for the same company. So a lot of people are entrepreneurs. Some of the people are entrepreneurs, not a lot of, but some of them can be billionaires. I mean, they can be unicorns, whatever you call them in a different language. They call unicorn and billionaires who found the company by themselves, though. We see that Satya Nadella probably used a H-1B. Maybe we have Google CEO and certain other people, though. So what, under the current law, though, if somebody wants to start their own company and then want to employ themselves, what are the restrictions available? You know, what's the difference between a U.S. citizen and a H-1B person? And then can the company file the H-1B and get the H-1B? That's for the current rules. And also for the proposed regulations, what are the differences going forward? I know that it's getting easier going forward. What's the current restrictions? What are the future restrictions?
Yeah, so right now, H-1B does not provide for self-employment. So you cannot start your own business and be the 100% owner and then sponsor yourself on an H-1B. There are a couple of issues with that. Number one, for an H-1B right now, you have to establish that there is an employer-employee relationship. And if you're the employer and the employee, there is no relationship. Therefore, you cannot get an H-1B in that situation. And then the other main issue is when you're in H-1B status, you're only supposed to be carrying out qualifying functions, meaning job duties that were specified in your H-1B petition, and those job duties have to require at least a bachelor's degree in a specific field of study, and it has to match that field that you have. So for you to be owning a business, that typically comes with a lot of administrative tasks, things that are not associated with actually carrying out the technical side of the business, but running to the bank, signing documents, running payroll, and those sorts of things. Those job duties are not H-1B level job duties. USCIS considers them to be non-qualifying functions. So for those reasons, it's really not possible for an H-1B worker to start their own company, be the 100% owner, and sponsor themselves for an H-1B. Now, there are some exemptions to that if you are a partial owner, if you can show that there's a way that you can be fired, basically. If there's someone above you, even if you're a part owner in the company, if there was someone else that you report to and that could fire you, that creates that employer-employee relationship and would allow an H-1B to be filed or allow you to be on H-1B in the current scenario, as long as you're restricting your role for the company to be one that requires the specialty occupation. So you can be working for your company as a software engineer, but you cannot be handling payroll, going to the bank, getting coffee and doing copies and that sort of thing. Going forward, what the proposed regulation would be is they would actually modify that to say basically an H-1B person could be the 100% owner of the company, and they can actually spend some of their time doing those non-qualifying functions as long as they're spending at least the majority of their time doing specialty occupation work. So it definitely would make it easier for someone to start a business and employ and sponsor themselves on an H-1B.
Emily, when it comes to the new regulations definitely are doing a very good job. When would the new regulations be effective though?
So I think it's going to come in stages because part of that regulation deals with the upcoming lottery, and they've made it pretty clear that they want to implement that change in time for this next lottery in March. So we might see that part of the regulation finalized in maybe January so that it can take effect for the next March lottery. The rest of the regulations changes might not happen for another 6 months before they are able to review all the public comment. We're still in the commenting period. We have through December to do that. So then it's going to take them 6-8 months to review those comments, decide what the final regulation is going to be, decide if they want to proceed with any of these changes, and then issue that final regulation. So we may be another 6 months to a year out from actually seeing this change happen, if it's going to happen.
Most probably seems that this administration wants it to happen. That's the way I see it. Emily, with regards to the green card though, when somebody changes, when they improve the job situation, let's say, for example, I'm an immigration lawyer. I am now going to be a senior immigration lawyer. Does that require new labor certification to be filed? And because some of the lawyers tell that we need to file an entire new labor certification for every category.
Yeah. Generally, if it is your normal career progression where it still falls under the same occupational category, the prevailing wage is basically the same, the job requirements are the same, the duties are the same, you're just moving into a higher level role, I don't think that impacts the PERM that's in process or an I-140 that's in process. Even after the I-140 is approved, I think you can generally take those kind of promotions without having to do the process again. There are definitely firms that take a much more conservative approach and say that any change to the job requires you to start over. I think that's kind of a waste of resources and, you know, a way to get additional fees to do that process over again. But it's tough if you're the employee who's looking at, hey, I'm being offered this promotion, and you check with your employer's immigration attorney and they're telling you, no, you have to start over. Then you have to make the choice. Is it worth it to delay my priority date potentially, or my ability to get the green card to be able to take this promotion? Or do I forego the promotion to be able to lock in my priority date, at least get my I-140 approved, and then decide from there? So that becomes a very difficult choice.
Most companies, at least 80% of the companies, don't require the whole labor certification to be processed again if it's a natural increment in the position, Emily. Especially the FANG companies, what you call as Facebook, Apple, Microsoft, Google, they don't require people to go through the entire labor certification again. And most of the very good, decent lawyers don't require the entire labor certification to be filed again. Now, of course, obviously check with the HR, because it's not us to decide, it's the HR and your immigration lawyer to decide. Now, there is two aspects here. Once the labor certification is approved, and so once the labor certification is not approved, definitely once the labor certification is not approved and the company doesn't want to proceed with the labor certification, you may want to consider foregoing, if they don't allow you to file the labor certification, if you have the promotion, you may want to forego the promotion to get the labor certification approval. But once the labor and I-140 is approved, Emily, and especially for those Indian nationals, though, it's taking a long time for them to get the green card, especially if they didn't file the 485 application. Probably it's worth for them to risk taking the promotion, and if needed, to file the labor certification, file the entire process again, though, if the company requires them to do so. What do you say about it?
Yeah, I think a lot of it depends on whether this is your first labor certification. If you've already got an I-140, maybe from an old company, your priority date's locked in, then I'm looking at, okay, how soon is it going to be for your priority date to become current based on that old I-140? Because you get to retain that priority date. So if you've got, you know, a 10-year wait and you've already got a priority date locked in, and your company's one that's saying, no, we have to start the process over if you take this promotion, to me, it makes sense to go ahead and take the promotion and start the process over, because you're not losing any time. The only time that becomes a problem is if we get a weird jump in priority dates, like what happened in October 2020, but those are kind of once in a lifetime situations. So that would be kind of the way I look at it is there already a priority date locked in? What is the likelihood or how quickly is a 485 going to be able to be filed? But if you're in the situation where this is your very first labor certification and maybe you're getting close to your 6-year limit, it would make sense to potentially forego that promotion to get your labor certification approved, get your I-140 approved, get that priority date locked in, get your ability to get those extended H-1Bs beyond the 6-year limit locked in. And then once you have those bases covered, then it's a little safer to take a promotion, change employers, and that sort of thing.
Coming to the point of the H-4 EAD, when people want to transition from H-1B to H-4 EAD, or from F-1 to H-4 EAD, how do they need to make sure that there is no interruption in the employment? The first thing is that try to file as soon as possible. So let's say, for example, if your OPT is or STEM extension is expiring, and let's say October of 2024, if you have the H-4 EAD option, though, don't wait for the lottery. File it right now, H-4 EAD, because it's taking approximately about 4 to even 8 months for you to get a H-4 plus EAD. You need to file H-4 plus EAD together, not separately. That's number one rule. If you get an occasion where your spouse is filing a H-1B extension, H-1B amendment, or H-1B transfer, you can attach the H-4 plus EAD together along with the H-1B. All three will be approved at the same time. You can do the premium process in the H-1B, you get the H-4 and the EAD approved at the same time. Now, you buy one, get 2 free here. And this is real, this is not fake. So try to attach the application together. And if it's not, where your spouse is not actually filing an H-1B right now, though, you need to file H-4 plus EAD. Try to file as soon as possible, though. So if your H-1B is, if your OPT or STEM extension is expiring in October of 2024, you can file it right now. You don't wait until September to file for the H-4 EAD. File it right now. Let's say, for example, you're coming to 6 years, you're coming near to 6 years. So don't wait once you go to the 5th year, 5.5 years, 5 years and 9 months and file the H-4 EAD. Try to file it as early as possible. In that way, the interruption will not be there. There are people who will say, what if the H-4 plus EAD will not be approved at the same time? It's very rare that happens. There are some ways to rectify that. There are something called Margarita switches and certain other things available for you if you needed to. But in general, though, you get H1, H4, and EAD together approval. Anything else, Emily, on this?
Yeah, I think some other options that could come up if you're in the situation where you've gotten the H-4 approved and maybe the EAD got delayed, or maybe you're outside the country and you need to get the H-4 EAD, but to get the H-4 EAD, you have to be in the U.S. in H-4 status. What I've had some people do is come in on H-4, not work while they're in the U.S. because they're on H-4 at this moment, file for the EAD, and then exit, and they can work remotely in their home country while they wait for the EAD to be approved, and then come back in on H-4 to utilize that EAD. So that's kind of another backup plan if things don't go as planned.
Emily, with regards to the Child Service Protection Act, when does it actually protect? As we know that if the child ages more than 21, also in some instances, they are protected before they get the green card. They will be considered to be under 21 and will be obtaining the green card. What are the conditions to meet if the child is meeting the requirement or not?
Number one, your I-140 has to actually be approved. And number two, your priority date has to become current, either under the final action date chart or the filing date chart if USCIS allows you to use the filing date chart in your filing adjustment of status in the US. So if all of those things are happening where you have the I-140 approved and your date is current, whichever chart that we are using that particular month, then you look at on the first of that month, what is my child's actual age? If it's under 21, they're fine, their age is locked in. If it's over 21 at that point, then we look to how many days was that particular I-140 pending with USCIS. You take the received date and the notice date and calculate the approval notice date and calculate how many days that was. Subtract it from the child's age on the first date of the month that the priority date became current after the I-140 was approved. And then if that takes the child's age below 21, then their age is locked and they're still eligible to file even though they've already turned 21. So it's very important. If you are getting close to that situation, maybe you're in the EB1 category where your date is current, but you're planning on filing your I-140 and your 485 together. Having the I-140 pending does not lock your child's age in. So you need to make sure that you get that I-140 approved before the date happens to retrogress. So that's where the big issue comes in for people when they have a pending I-140 is if the date retrogresses and they're not able to file that 485, that can take the child out of being able to apply with the rest of the family.
Anything else, Emily, before we go to questions?
I think we can move on to the questions.
David has this question. He's maxing out on L-1B. His priority date is about to become current. What are the options? Can he go outside, do the consular processing? Can he convert into B1B2 and change the status back? It may be appropriate. There are many different options that are there. If you have other options like H-4, L2, definitely you should take those options. Going outside the country seems to be a good option too for you, spend a little bit of time, but I don't know whether I'm going to go with the consular processing. You can always go outside the country, spend some time, and then come back into the country again on L-1B, the leftover period that you have. Let's say, for example, you've used up 4 years and 6 months or 4 years and 9 months. You can always go outside the country and come back for the rest of the 3 months later on and file the 485 while you're in the country. I would like to file the 485 while you're in the country rather than do the consular processing.
Srinivasan says, what happens when a student who's on F1 with OPT gets the change of status to H-1B that took effect on October 1st? Their F1 visa stamp that's in the passport already expired last year, or expires in July 2026, I guess. And the students I-94 when they entered said D/S on it, but now they have a new I-94 on their H-1B that ends in 2026. Does the automatic visa revalidation rule apply to allow this person to visit Canada for 15 days? Yes, it does. So it works for someone whose visa stamp has expired, or they have a visa stamp in an old category and they received a change of status while they were in the US. So automatic visa revalidation works if you have a valid I-94 for your current status that is not expired, and you have an old visa stamp in your passport that's either already expired or is in a different visa category. You're traveling to Canada or Mexico, staying there for less than 30 days, and you're not going for stamping, you can use your old visa stamp that's in the wrong category or that's expired and your current I-94 to re-enter the US without the need of going for visa stamping.
Question that comes from Abdul from Facebook is that when does a rule for the EAD for the people who have had an I-140 approval for 5 years, when does the rule come into effect? We don't know. We request that you contact the congressman and the administration. We have given a draft of it. But at this point of time, we cannot tell if it's going to come, when it's going to come. It will all depend on how many letters will go through for you. Question from Naveen. He's an H-1B, as I-140 is approved. How long it's going to take for the green card? Assuming for him the green card and the child may become about 21, is his worry. Naveen is from Facebook. Yeah, I mean, there is a chance that your child might be aged out, especially if your priority date is in 2019 to 2023. Definitely, there's a great chance that the child will be aged out. What can you do right now? Of course, keep writing the letters that we have drafted here. About 3 letters to different kinds of letters are there. Please keep writing those letters to the Congressman administration. Other than that, what can you do is that you need to prepare yourself mentally. You need to prepare your children mentally that they're not going to get the green card and what is their future in the United States or wherever they want to look into.
Roy says, can an H-1B holder with an approved I-140 work remotely from outside the U.S.? And if so, for how many days? Well, it depends on the country you're going to work remotely from. So if you are going to your home country and planning on working remotely, I'm assuming that you are authorized to work in your home country. So there's no limit. You can work there as long as you want to. Has nothing to do with your H-1B status. You don't need an H-1B to sit in your home country and work. Now, if you want to later be able to come back into the U.S. and file for the adjustment of status, you need to make sure that before your priority date becomes current, your employer filed a new H-1B at that time. It's not subject to the cap because you've already been counted and you're using your approved I-140 to extend beyond the 6-year limit. Then you get the visa stamp and come back into the U.S. and then you file the 485, assuming you're with the same company. If you're now with a different company, before you can file the 485, you need to have a new labor certification and new I-140 approved with that new company.
Vasu is asking the question, can we sue the USCIS because they're not adjudicating the 485 application based on the priority date, they're just randomly doing it? I don't think so. That will be fruitful, Vasu, if we do that. We have evaluated that and we have ruled out legally we won't be able to achieve any, we won't be able to get the result what you deserve if we take you to the court. Suresh has this question. Can the H-1B person hire another person on H-1B? Suresh, the way you need to look into is that, can you own the company? So technically speaking about people who are on H-1B can own the company. Once you own the company becomes independent though. So let's say Reddy Neumann PC, maybe Emily and I am owners of the company, but Reddy Neumann PC is individual by itself though. It exists without Emily, it exists without Rahul. It is an individual, it's an individual itself. Now the question need to be asked is that, can the company hire a H-1B? If you already own a 401k, you probably own Microsoft. Somewhere in the mutual funds, the Microsoft, so you're an owner of the Microsoft. And Microsoft does file the H-1B. So technically speaking about, that's allowed. So there are ways in there where you can own the company and the company can still file the H-1B. But if you intend to do so, please contact an immigration lawyer. The major problem that comes with the ownership of the company for us is that, as Emily has pointed out, that you cannot work as a CEO of the company. You cannot work as a director of the company, at least under the current regulations. You can't be signing the documents. You can't be signing the leases. You can't be operating the company. Can you own the company? Let's say, for example, your uncle or your cousin who's a U.S. citizen or green card holder want to operate a company and he wants to, there is an expenditure, it's a 50,000 or 100,000. He takes the money from you and then he starts the company and he manages the company. He takes your investment and gives you the share certificate and gives you the profit. Is that allowed? Absolutely. Can you go and recruit the people for that company? Can you work for that company? The answer is no, you cannot. But can that company hire individuals? Yes, they can.
RC asks if there's any update on the FOIA request related to I-485 and adjustment of status. So he's referring to a Freedom of Information Act request that Stephen Brown from our office filed a little while back, basically trying to get some additional data from USCIS regarding how they're processing 485s, how many they have pending, what are the priority dates, basically where did that inventory go that we used to get back in 2016 that stopped all of a sudden. So no, we don't have any updates on it, and we don't expect any updates on it. USCIS is horrible at responding to FOIA requests on time. There is a deadline set in the statute that they're supposed to respond by. They generally do not, so we do plan on having to sue them in order to get the data we requested.
Mayank has this question. What happens if the person is an H-4, files the H-4 EAD while being in USA, then go back to home country? Can he get an L1 visa instead? If you're eligible for, absolutely, you can get it. Just because you have an H-4, just because you have an EAD that you applied and pending, can you still be eligible for the L1 visa? Absolutely, you're eligible for. Couple of questions. One is Mihir is asking this question, and also Jay is asking that question. Are you expecting a third lottery? Yes, we are expecting a third lottery. Most probably, it will be coming in the month of November, in this month. By the end of this November, we are expecting some results, because the October 30th is the last day to file the application. They take a little bit time to process all these things. Once it reaches the USCIS, it takes a little bit of time for them to process. So somewhere in this month end, we are expecting a third lottery. Why do we see that? Oh, we have seen some companies file 2,000 H-1B lotteries. I've seen, Emily, the Freedom of Information came out with what Stephen has got it. We have all the information of all the companies that filed the H-1Bs. I think so only we have that information. It's not public information at this point of time. We got it for information that we filed last year. That was on the last year's quota though. So they were filed 2,000 H-1Bs, a small consulting company with only 10 employees. So yeah, so there are some more companies in this year lottery, 2023 lottery, that we, 2024 lottery, we are not aware of it right now. We did file the Freedom of Information. So there are a lot of companies that file thousands of H-1Bs there, and the lottery, they got hundreds of them, and they're not filing any of those. And we do expect a third lottery based on that.
Yeah, I think the last time we had the third lottery was on November 14th. So maybe by the end of next week, we should have something, if they do it like they did before. Syed says, my 6-year H-1B is expiring October 18th, 2024. My PERM was filed November 1st, 2023. So not exactly 365 days before the 6-year limit is going to be reached. And he wants to know, can I apply for the H-1B extension on November 1st, 2024 with that 13 days of gap and stay in the US for that period? No. You are only eligible for an H-1B extension if you're going to be maintaining your current status up to the start date that you've requested on that H-1B. Since your current status is going to end October 18th, and you can only request a November 1st start date, that gap will cause your extension to be denied. Your company can file a consular processing H-1B with a November 1st start date. You can leave on October 18th, go for visa stamping, and come back 10 days before November 1st in order to get back to the US. So that would be the other way around that. Otherwise, you've got to file a change of status to some other visa category, like maybe an B2, and then file a change of status back to H-1B once the 365 days are met.
Abhijit has this question. Can I use my wife's priority date for the cross-country chargeability? I don't know if you face the question a little bit differently. Cross-country chargeability normally applies. Let's say you are from India, and let's say your wife is from Cambodia. You can use the priority date. So you have a priority date based on your Indian citizenship. The priority date is backlog very much. Based on Cambodia citizenship, the priority date is current. You can file the 485 along with your wife saying that her country of birth, which is Cambodia, and then file the 485 application. That is called cross-country chargeability. But let's say, for example, your priority date is 2015 and your wife's priority date is 2011, okay? And then you want to file the 485 based on your I-140 application with your employer. Can you use your wife's priority date? The answer is simply no. Arindam has this question. he is an Indian, he's born in India, is an Indian, he was an Indian citizenship. Right now, he's a Dutch citizen. Can he apply for the green card lottery? The answer is no. The country of birth will determine where you are eligible for, Arindam. Unless your wife is a Dutch, in which case you can use the cross-country chargeability, just like what I said to Abhijit Sen, you can use a cross-country. But if you and your wife both are born in India, you cannot apply for the green card lottery.
Aliasar says, do we expect the EB2 rest of world to become current anytime soon? My priority date is April, but the visa bulletin is stuck at July 2022. I don't think EB2 rest of world is going to be current like it used to be, but I would expect it to move forward some in January. That was when the second quarter of the fiscal year starts and we have next quarter's green cards become available. That seems to be what USCIS is doing this year. But I don't expect it to become actually current anytime in the near future.
Is there any minimum time the STEM student has to study in F1 to be eligible to get an OPT? There's a plan of switching from H4 to F1 for my daughter. Is your question that they need to study a certain period of time in F1 or a certain period of time for getting the OPT? Yeah, it definitely is 1 year, which is 2 semesters actually, for you to get an OPT. But could you only spend only 1 semester on H4 and 1 semester on F1 and still get the OPT? Yeah, you can. You can. But the coursework must be the minimum of 1 year coursework for you to get an OPT.
Boston says, why would USCIS not adjudicate applications in the order of the priority date? I'm sure we're seeing 485 applications approved, not first in, first out. They're not going by file date. They're not really going by priority date either. Why is that? I mean, I think part of it is incompetence, but I will give them some benefit of the doubt to say there are some difficulties there. Number one, just because your priority date is current, what if your I-140 is not approved yet? They have to put that 485 on hold. They can't approve the 485 until the I-140 is approved. So that makes it impossible to go by priority date alone. And number two, because USCIS allows the retention of an old priority date and the transfer of underlying basis, you constantly have people changing categories that are really jumping ahead in line because they have an earlier priority date. So those two things make it very difficult for them to just hold everybody else's 485 until someone with a super early priority date has both the I-140 approved and they happen to jump in line and file yesterday. But because their date is earlier, they should get approved first. That's what makes it difficult.
And also, especially in 2021 and 22, though, because of the court cases and certain other things, the USCIS has taken a high priority to complete the amount of available green cards. So they made a policy, whoever got the file, I mean, whatever file they got it, they just started approving it as long as it's current. They didn't look into whether the priority date was 2010 or 2014. And yeah, you asked a correct question. Can we sue them? We consider that, and no, we don't think so. It's a good idea. Abhinav Shah has this question. He has an EB1A approved, and recently we're seeing a lot of EB1A approvals. If you think so, you're marginally qualified, please contact our office. So the person who is in our office is Kareem. He's a very good EB1A lawyer in our office. Now, coming to the point, what he says is that EB1A is approved. His 485 is pending from 2020 under EB2. What do you do under the transfer of underlying basis? Send a letter to the USCIS indicating that you have an I-140 approval under EB1A, should be considered under EB1A. And wait to see for about a month and try to contact the congressman or ombudsman to see if they would adjudicate the application. And if they don't, you may want to consider suing the USCIS. That's the best way to get the response from the USCIS right now.
Gotham says he has a valid stamping on his passport, but he changed his employer recently and that transfer application is in process, not yet approved, and wants to know, can he travel and come back with the previous visa stamping? So technically, yes, that stamp remains valid and you could potentially come back and show the receipt notice of the pending transfer, but that only works if your previous H-1B has not yet expired with the old employer. And be aware that you're only going to be given an I-94 till the date that the old H-1B expires. So for that reason, I generally would not recommend it. It's best to get the H-1B transfer approved, and then you can still travel with the previous visa stamp as long as it's not expired and show the new approval notice at the port of entry. Then you'll get the new I-94 till the full date of your transfer approval.
Question from Pujita is, can I apply from F1 to H4 plus EAD? Absolutely. If you're eligible for H4 plus EAD, you can apply both the things at the same time. No problem with it. This question comes from Puneet Singh Ladu. He's an H-1B. He's been waiting. He filed the 485 application on F2 category though. He already got an EAD on that category, and he has an EAD until 2025. Is it risky to start working on EAD? I don't think so. When I was in a very similar situation like you, Puneet, I did use the EAD application. Very similar, not exactly the same, but I did use the EAD though. I mean, I don't think so if you're especially F2B category or F1A category also, F2A or F2B category, I don't think so you're at risk. And if I were you, I would use the EAD and start my own company if you can.
Abhijit says, is USCIS going to reject an EAD AP renewal application if it's filed earlier than 6 months before the expiration date? Generally, no. I've only seen an issue once when we started filing super early for these renewals. And in that situation, I think the EAD was expiring maybe 10 months ahead, but the AP was valid for an additional year. We filed both renewals together to try to get the combo card to have the same end date. And they did approve the EAD card with the 5-year validity, but they denied the AP, saying you already have an AP that's valid till 2024. This was late 2024 at this point, so we're not going to give you another one. I've only seen that once in all of the renewals we've been doing. I will say they're getting a little bit better on their renewal processing times. I've seen a couple approved in 2 months lately. So hopefully that continues to improve so you don't have to file that far in advance.
Kranti Kumar says that if the EAD and AP rule is approved with a 5-year wait time, will the candidate become independent of employer? Yes. That's the purpose of the particular rule that we are requesting. The draft is provided in Emily's blog. Please look into that thing. Jitendra has this question. His priority date is December 2015. My employer name changed after the I-140 approval. Should I file an amendment? It will depend mostly on, was there a change in the tax ID number though? For example, Reddy Neumann PC used to be law office of R.V. Reddy PC before, and then we changed to Reddy Neumann PC. So with the tax ID number, everything continued the same. So the company has not changed. In that case, you don't need, even though the name has changed, you don't need to file another I-140 application, as long as, again, will depend on how the tax ID number has changed. Most of the time, you don't have to file the labor certification again, but you have to check with your HR whether it requires a labor certification to be filed again.
Prashant says the I-140 is approved. I'm assuming he's currently on H-1B and planning to change employers after 6 months of the I-140 approval, but wants to do it by switching to H-4 EAD and wants to know, can I still come back to H-1 later when the new employer applies? Yes. So once you have your I-140 approved, if you're on H-1B and you change status to something else or you exit the country, you can use that old I-140 approval to get another H-1B that is going beyond the 6-year limit. You don't have to go through the lottery again. You can file at any time of year. And you just have to make sure that it's filed while your priority date is not current. Once your priority date becomes current, then you only get 1-year extension of your H-1B instead of 3 years.
Kaushik Malik, as an H-1B, can I become a Udemy teacher or can I have an online courses of my own? Assuming that you are going to get a payment from these things, the answer is clearly no, because you're working in the United States. You don't have the H-1B authorization to work for that particular Udemy or whatever online courses. You don't have the, it doesn't allow you to work, so you're not.
Pujitha says, is a change of status possible from F1 to H4, and can the H4 and H-4 EAD be filed concurrently? Yes, that's absolutely possible. So I'm assuming your spouse is in H-1B status and your spouse has an approved I-140. So as long as you are maintaining your F1 status, you can file a change of status to H-4 and file the H-4 EAD along with it. And they're generally both approved together. If you are currently on OPT, you want to make sure to file that early enough so that your OPT doesn't expire while you're waiting for the H-4 EAD to be approved.
Kiran has this question. His wife just received a H-4 plus EAD. Can she do multiple things? Can she work part-time job, full-time job? Can she work part-time, full-time, and then she can own a business? The answer to all your questions is yes, yes, and yes. Your H-4 EAD doesn't have any restriction, none whatsoever at all. She can do anything, absolutely not a problem.
Sam says, I did my first stamping in my home country. Can I do my second H-1B stamping in Canada? Yes, that is allowed, Canada or Mexico. Both of those are fine. They were a bit restricted during COVID as consulates across the world were shut down and were only helping their own citizens. But now that things have opened back up, you can basically go for stamping at any consulate, right, as long as you can legally get into that country.
Question from Ram. He has a H-1B stamped in his passport. He went for L1 visa. They stamped L1. Does it mean that his H-1B is being cancelled with prejudice or without prejudice? First of all, on the passport, check it if it's been cancelled. Sometimes they won't even cancel the H-1B though. If it's not cancelled, you can come here on either H-1B or L1. There's two options will be there for you. If it's been cancelled though, you need to check, it says it's been cancelled with prejudice or without prejudice. But if it doesn't say anything, that means that it's without prejudice. That's the way I read it. If it is with prejudice, that means that there is something wrong with it. But if it doesn't say that, you're good. Most probably it will be without prejudice. If nothing is there, that means it's without prejudice.
Vasan says, where can we find more updates about the pilot program of H-1B stamping in the U.S.? So right now, that potential regulation is with the OMB for review, if I recall, unless they finished it already. But there should be a proposed regulation published. Let me go back and see if they've already finished their review real quick here. Oh, sorry, wrong agency, that's why.
I would just recommend you Reddy Neumann PC YouTube would be the best source. Because it's very hard for people to go here and there, search and understand the regulations, what are coming, Emily? OMB websites and all those things. Oh, the best thing is come here, we'll update you every week.
Yeah, just to give you an update of where it's actually at. So OMB received the proposed regulation on October 17th. So OMB is kind of an oversight agency that reviews all government agencies' regulations before they actually get published to make sure that none of them conflict with each other. So that was given to OMB October 17th. Sometimes they take weeks to review, sometimes they take months. I would expect they'll probably finish their review maybe by the end of the year, then it'll actually be published, then we'll have actual commenting time. So hopefully next year, sometime it'll actually be a reality.
Ahmed Khan has this question. To calculate the Child Service Protection Act, also called as CSPA, with the I-140 needs to be approved, I have both downgraded EB3 and EB2 I-140 approval. Which one should I consider it? Depends on for the 485, which one are you using? Are you using EB3 or EB2? If you're EB3, then you have to deduct the time period that the I-140 is pending for EB3. If you're using EB2, then you have to deduct the time period that you are using for EB2.
Deepak says, can someone on H-1B earn additional money from rental income? Will that be any issue? I think it depends on how exactly it's done. If you have a second home and you decide to, purchase that for the purpose of renting it out and you're doing year-long leases, I don't see any problem with that at all. If you now have 10 homes and you're renting out all of them and you're doing all of the maintenance and you have to be a property manager, now maybe you're spending a little more time renting homes, and maybe that's your new business versus actually doing your H-1B work. So that's where it gets a little risky. And then the other thing is with these Airbnbs, I believe you get a 1099 for that. So that's miscellaneous income or independent contractor income, not rental income. And with some of these Airbnbs, it requires a lot of work. If you're renting stuff out every single weekend, are you the one that's going and cleaning it and getting it ready for the next tenant and all that sort of thing? So I think it really depends on what exactly you're trying to do with that rental that you have.
Priya Pulva from YouTube has this question. Can a H-4 EAD person self-petition on EB-1A if they meet all the requirements? Do I need to be on H-1B to get H-1B to begin with? Absolutely, you don't need to be on H-1B. You can be on H-4 EAD, and based on H-4 EAD, you can still file. The EB-1A application. You don't need to be on H-1B. Question from Bhavneet Soni. He has filed a EB-5 application called I-526. When you file I-526 from past about 1.5 years, you can file the 485 application. Based on that, he got an EAD approval. Now his I-526, which you could say very similar to I-140, that one, got denied. Now his question is that, is the EAD valid? No, EAD is not valid. Bhavni, there is another question. If you have used the EAD though, you have to get back to the non-immigrant status though. You may have to leave the country and get back to non-immigrant status. You may want to consult an immigration lawyer because your I-526 is being denied. Emily, there are a lot of people are right now moving into EB-5, and it may be fine for them to move to EB-5. It's $800,000 investment, especially now they need to invest in a rural community because the priority date for Indians are backlogged a little bit. A lot of people say it's 100% guaranteed that their I-526 will be approved, their temporary green card will be approved, everything will be approved. Do you believe them?
Definitely not. Yeah, I mean, there are certainly good investments out there. There are certainly good regional centers out there, but no one can ever guarantee anything, especially with immigration. So if someone is guaranteeing that you'll get a green card or you'll get an EAD in a certain amount of time, if you go through their regional center, I would run the other way. There are so many, just because they're a regional center, I mean, yes, they've been approved by USCIS to be a regional center. That definitely does not mean that they are a good regional center or they're a good investment. It just means they've done the bare minimum to prove that they exist. So don't rely on USCIS's approval of them as a regional center to say, hey, they're good. We see so many lawsuits come out of EB-5 investments where the investor sues the investment because X, Y, and Z, things didn't work out. So be very careful with that. It is an investment. Your money is at risk. You need to have the good financial background, and an immigration attorney cannot be advising you on the financial aspects of whether this is a good investment or not. Our job is just to advise on the immigration side of things. So be very careful of that as well.
And it's always better to hire an outside lawyer than the lawyer that they are suggesting to go with. Especially these investment agencies, so they always suggest to go with their own lawyers. It's always good to go with an outside lawyer so that you will have an independent evaluation on the legal aspects. As Emily has pointed out, that we will not advise you on the investment because we don't have a license, we don't have a expertise to advise you on the investment. You are an entrepreneur, you made good amount of money. You should be able to study it better than us. So we leave that one option to you though. But always have an independent lawyer than the lawyer supplied by them.
Venkata says, I'm here on in the US on an L-1B. but I also have an H-1B approved from back in 2017, but never got the stamp. Can I use this H-1B and change the job? Most likely no. So even though it doesn't have to do with how long ago the petition was approved, there's no requirement that you have to use it within 6 years. The problem is you never got the stamp. So I'm assuming this was not a change of status to H-1, so there's no I-94 on that approval. And you mentioned you never got the stamp. In USCIS's eyes, you've never actually been counted in the lottery. And you're still subject to the cap. So the only way for you to get an H-1B now is to go through the lottery again.
Sumit has a question. He was working for company A from Facebook. Sorry, his question is from Facebook. He's not from Facebook. He was working with company A. He moved to company B on H-1B. His wife's H-4 transfer has not yet occurred. Can he move to company B working even if the H-4 for his wife has not been approved? The answer is simply yes. You can move to company B. You don't need an approval. You don't need an approval from company. You don't need an H-4 approval for your company, for your wife on company B for you to move. Absolutely not required.
Amit says, I have an EB3 I-140 approved with the 485 pending. Already have the EAD and AP from that. This is with the old employer. And now that he switched to a new employer, he's eligible for EB2 with the new employer and wants to know, should he go ahead and start the EB2 process or wait for the EB3 to become current? Since we cannot guess which one is going to become current first, if that employer is willing to do another labor and I-140 for you in the EB2 categories, you have both. I don't see any problem with going ahead with that.
Can I recapture my H-1B days by spending 2 weeks in Mexico using automatic revalidation? Absolutely, you can. No problem with it. No problem with it.
Mukesh says, can I travel with an extension pending for parole after my H-1B extension is already approved and I'm planning on going for stamping? So we've got advanced parole, filed the extension for the advanced parole, which is still pending, also has the H-1B approved and is planning to go for stamping. So yes, H-1B holders can choose to travel on advanced parole or choose to travel on H-1B without negatively impacting the 485. So that part is fine. Whether it's going to impact that pending advanced parole depends on whether you're going to return before the current advanced parole expires. So that would be the only thing. You may have to refile that advanced parole extension, but no issues for the 485 itself.
My dependent spouse H-1B was shortened I-94. Can she go to Canada to get the stamping? Yeah, she can. Can she extend the H-4 EAD based on that? She can go to Canada. Absolutely, that's not a problem. But for her to go to Canada, she need a Canadian visa, though. Selva Kumar, here is the issue, though. If your wife's H-4 is expiring somewhere in 2024, let's say June or July of 2024, though, it may be appropriate for you to just file the extension while she's in the United States and get it extended here rather than actually making the trip. But if it's expiring very soon, though, yeah, it probably is worth for her to go get the H-4 extension. But what we are recommending people is that when they are going to Canada or Mexico to extend it, for stamping, you can go, absolutely not a problem. But there are some ways where you don't have to go to stamping. You just need to go to Mexico or Canada and come back, show your H-1B and get the H-4 extension based on your H-1B. If you're doing that, though, the best way to approach is to file the H-4 and EAD extension. Then she travels to Canada or Mexico and she shows your H-1B approval to come back, saying that, look, my I-94 is expiring in January 2024, but my husband's H-1B is expiring in January of 2026. And please give me the I-94 until January of 2026. And they do give the H-4 until 2026 without going for stamping. So you may want to consider things without going for stamping rather than going for stamping.
Rajeshwari says, when the H-1B entrepreneur rule takes effect, can I be on 2 H-1Bs, one with my current employer and a second one at the same time as an entrepreneur? We won't know until the actual final regulation comes out, but there's nothing in the proposed regulation that seems to prevent this. So you would need the H-1B for the entrepreneur, your new company, to be the concurrent H-1B. On concurrent H-1Bs, they can be part-time or full-time. If they're going to be part-time, you may want to consider putting a range of hours if you're not sure how many hours each week you'll be working in your entrepreneurial position. But as of right now, it seems like that should be doable.
Question from SK. He's from Texas, and they have been a green card holders from past 1 year. His wife wants to terminate pregnancy, and because of some legal issues, they cannot do in Texas. If they travel outside to a state where it's perfectly legal, and they come back, will they have any problem in getting the citizenship? Absolutely not a problem. Absolutely not a problem. Let's say if you go to Louisiana and it is legal in Louisiana and you come back to Texas, it's not a problem at all for you to get the citizenship. This pregnancies, these kind of things are more federal issues. So citizenship is a federal issue, so you will not have any problem whatsoever at all in getting the citizenship.
Uma Maheshwar says, is the pending transfer of underlying basis considered for the Child Status Protection Act, or does it need to be approved, the transfer of underlying basis? He had an EB2 I-140 approved before applying for the TUB, or transfer of underlying basis. So it depends, was the age already locked under the original category that you qualified under? And is the age locked under the new category? The most important thing is under the new category, the child had to seek to acquire within 1 year of that date becoming current, and filing the transfer of underlying basis is considered to be them seeking to acquire. So there's a couple of different things that we would need to know to figure out if the Child Status Protection Act applies or not in that situation.
Amit has this question. Does the USCIS, he has his EAD approved for 2 years, his AP is pending. Is the USCIS adjudicating the advance parole for 5 years for everyone on case-by-case basis? Emily, my experience has been, it's been 5 years, is that right, Emily? They're approving everybody for 5 years or some people for 5 years? I think so.
I've seen everything for 5 years.
Everything, okay. I haven't seen anything approved for 2 years recently. So it's just very limited time. So anybody whose EAD or advance parole is approved recently, though, in the past 2 weeks, please give us a comment that whether your EAD is approved for 5 years or 2 years or 1 year. Please comment. As of our knowledge is concerned, right now they are doing it 5 years. Most probably for you, the advance parole should come for 5 years. Prashant has this question. Can an H-1B employee for other company can start a Shopify business? I don't know what Shopify is. I'm assuming that you will have some materials buying and selling, and you will make money on it. You will have to work on it. The answer is no to that question.
Arar says, my final action date became current in the October visa bulletin. So how long does it take to get the green card? Is there a way to follow up with USCIS? Currently, it's just showing that biometrics are complete. So there's no way to follow up with USCIS unless your case is actually considered to be outside normal processing time, which they're currently listing normal processing times is anywhere from 24 to 36 months. So I'm assuming your case is still within normal processing time, even though that's completely unreasonable. So you won't be able to follow up with them and do any kind of service request. That also means probably congressional inquiry is not helpful as well, because they'll just say, hey, it's within the normal processing time. It's possible that litigation may help depending on other circumstances of the case. So you may want to reach out to Stephen Brown in our office to see if litigation may be able to help in that situation, depending on how long your case has been pending total.
Anything else, Emily, before we close?
I think we're out of time. So please remember to hit the subscribe button so that you will be notified whenever we are going live or have any new video updates. And don't forget, we do have a daily conference call that's also free that you can join and get your questions answered. You can go to rnlawgroup.com, click on free resources, and you'll find the schedule for our conference call.
And if you want to speak with us privately, with Emily, me, or any of our colleagues, our schedule is available online. You can block a time that's suitable to you. The link is provided in the video. And the conference call, the free daily conference call link is also provided in this video, where you can come in every day, half an hour. We are doing it from past 11 years, from 2012 onwards to right now. We're doing free conference call, and now we converted to Zoom call. So it's been going on from 11 years. Thank you for giving an opportunity to answer your question.